cover even this part of the conversation. The disadvantage of nationalization where it was not implemented properly. So and now I talk about those disadvantages. The disadvantages of nationalization is that by the late 1970s, it became increasingly apparent that many of the industries nationalized between 1945 and 1951 were running into difficulties. The major problems that the industries faced were they were managed ineffectively and efficiently. That's a key point. I want you to note down that there's no point nationalizing and then, but those institutions that are nationalized are not run effectively. So effective governance is key. Because there's no point, as I said, nationalizing, but there's no proper form of governance. The principal agent problem is highly relevant to public sector activities, given that the managers of the utilities were generally not required to meet any efficiency objectives set by the state. So basically, when institutions are under, you put them under state control, I think this is addressing where you need to put targets. You need to put goals. There needs to be performance management, criteria of managers, of directors. You need to to check the efficiency, of how all of these different managers or people who are involved in operations, how they do their roles, can they do their roles effectively? So you need efficiency objectives. There was growing criticism that because these industries were protected from competition, they had become increasingly efficient. Nationalized industries were also prone to suffer from moral hazard, which occurs whenever individuals or organizations are insured against the negative consequences of their own inefficient behavior. For example, if a particular nationalized industry made operating losses, the government would simply cover those losses with subsidies, knowing that the taxpayer would come to the rescue, meant that the inefficient behavior would continue. So it looks like some officials become complacent. Officials operating in nationalized institutions, they become complacent, and knowing that, for example, the government can always step in whenever the institution needs help from the government to step in. So, but the major point I think is that there must not be complacency. There must be efficient performance measuring mechanisms and criteria. Even if, for example, the government can come and cover losses that are made, or the government can intervene in any way, but that is no excuse. That is no excuse. You must not be complacent, and this is something which public officials must understand. There's no room for complacency. There's no room for inefficiency, and there's no room for incompetence. This is perhaps the most significant criticism of the recent bailout of failing banks, given that they know the taxpayer will bail them out. This may be an encouragement to continue with the inefficient and high-risk lending activities. In addition, the nationalized industries had limited scope to raise capital for long-term investment and modernization because they would have to compete with other government spending departments like education, health, and defense. The result was a prolonged period of underinvestment in these industries. Before I continue, so basically, here the another issue looks like to consider with nationalized institutions is that we must make sure that they stay modernized. We must make sure that they stay up to standard with industry standards. And so that's one of the things to consider. They must stay up to standard with regards to innovation. So we must give room for innovation if you're going to nationalize institutions. Okay. Now, these are the things that you must consider with regards to the nationalization of the South African Reserve Bank. I want you to pay attention. Okay, I know you've been paying attention, but we're going to mention the very important things to consider, because these are the things that experts have been talking about, economists, politicians have been politicians have been talking about in parliament from different political parties. Um, so yeah, so I remember some of the EFF, they like mentioned the opinion. The ANC mentioned the opinion, and as well regarding this, many other economists mentioned the opinion, and even political analysts as well. So these are the things I want you guys to consider. This is very important in the conversation. The things good to consider as we're talking about the South African Reserve Bank, the mandate, the independence and the role of the SARB. Point number one. So yeah, and as I continue, guys, okay, fine. I won't get into these things, these different things or aspects. I won't get get into detail with them in this episode, but we're going to talk about these things in more detail throughout the series. Number two, constitutional and legal process involved. Example, Section 25 of the Constitution. I want everyone to look up Section 25 of the Constitution, and we'll talk about it in more detail as we go along in the series. Legislation governing the SRB, legislative changes that need to be made in order to nationalize the SRB, economic and fiscal situation of the country. You must consider the economic and fiscal situation of the country. Is it feasible at the moment to nationalize the SARB? We must consider that. If not, when will it be feasible? What are the conditions that are needed to make this, to make nationalizing the SRB feasible? These are the questions that we must ask. We need specifics here. So this is the kind of conversation that we must have. You need to consider the rand and the markets as well. You need to study, for example, the rand. How does the rand, in this conversation that we're having, how does the rand come into the conversation? The markets, how do they come into the conversation as well? These are the things to consider. The investors, we're going to talk about investors, who are South African investors, who are investors, who are investing in the South African economy. These are the conversations we are going to have. What the Constitution says about compensation, these are the conversations we're going to have. So that's why I'm very excited about this series, because we're going to talk details here. We're not going to talk political rhetoric here. You see, international law about compensation. We talked about a resolution, the 1803 resolution earlier on. We mentioned that in the beginning of this episode. Okay. In November 2020 last year, it was known that shareholders we're talking about the SRB. In November 2020 last year, it was known that shareholders at the annual general meeting have the right to appoint 7 of the 15 directors and the financial auditors and determine the remuneration of the auditors. The government appoints the other 8 directors, which include the governor and 3 deputies. Consequently, the government already appoints more than 50% of the board. So basically, this is how, basically, we're talking about the SRB now, how it operates now. This is the SRB now, actually. The government already appoints more than 50% of the board right now. So I'm sure somebody is gonna ask, then why nationalize it if the government already appoints over 50% of the board? Why full state control? I'm sure those are the questions some people are asking, and we're gonna answer those questions as you go on throughout the series. So you're going to find that the discussion is more than just about the the government appointing all of the directors and all that. The government appointing all of the people on the board. The conversation goes beyond that. And then that's what we're going to talk about. And basically the conversation is all about the people in the society. It's all about the poor, the disadvantaged. That's what the conversation is about here. And we're going to actually just go in that direction as we talk more about this. That's why I say to you, this is more than just about the government just having full state ownership. It goes beyond that. It's about the people. Okay. As we continue reading, it also contains safeguards to prevent undue influence by shareholders. For example, this SARB Act, the South African Reserve Bank Act, prevents a shareholder and associates from owning more than 10,000 shares, and shareholders must be resident in South Africa to be able to vote on bank matters. You know, and I just want to emphasize that it's possible for you not to be born in South Africa, but then to be a resident of South Africa. It's possible. So, and then, okay, according to Section 4A of the Act, the role of directors is limited to matters of good corporate governance and selected financial matters such as approving the budget and financial statements. The current Act stipulates that all the